Well, hello everyone. Thank you for tuning in today. Welcome to Stein for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, medical malpractice, striking law, workers' compensation, pedestrian injuries, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. More Injury Funding is a sponsor, member, associate board member, or business partner of this podcast, Georgia Trial Lawyers Association, Academy of Truck Accident Attorneys, Sandy Springs Bar Association, Georgia Association for Women Lawyers, Georgia Association of Paralegals, Atlanta Legal Aid Society, State Bar of Georgia, St. Andrew Rowing Club, Georgia Hispanic Chamber of Commerce, and Georgia Council of Chiropractic. In today's episode, I have a very special guest, personal injury attorney Josh Stein, the founder and managing partner of J. Stein Law Firm based in Atlanta, Georgia. The J. Stein Law Firm handles a limited amount of cases to enable 100% focus on each client. They are committed to thorough and proper counseling through the entire process, starting on day one with their clients meet directly with Joshua through corresponding directly with them until solution. Today, we'll delve into a very interesting topic of valuation of personal injury cases. At the end of our episode, I prepared a fun pop-up question for our guests, so stay tuned. Welcome to the Sign for More Injury Funding podcast, Josh.
Hey there, Laura. How are you doing today? It's good to see you.
Good to see you again. Thank you so much for joining us. People have been asking about you, so I'm so glad we could make it happen again.
Oh,
Uh,
that's very kind. Yeah, I saw you a few times over the last couple of weeks on the holiday party circuit and at all of the continuing education fun events. So I'm glad we could do this again. I had a good time with you last time.
It's amazing, absolutely. So, can you please introduce or reintroduce us to your law firm and provide a brief overview of the types of cases that you handle?
Sure. Appreciate the introduction. Yeah, we're a small firm located by the Battery near where the Braves play. It's me, one other lawyer, a couple paralegals. We keep it small. We keep it lean and mean so that we can give, undivided attention to just the select cases that we do take on that all involve, significant injuries. That's the one common thread of the cases that we handle, whether it's a car wreck, a truck wreck, a slip and fall in a restaurant or business, whether someone's hurt, a child hurt at daycare, like a security case, a dog bite, really all across the gamut of ways that people can get hurt. We are here to help them.
Excellent. And let's jump right into understanding valuation. What factors contribute to the overall valuation of personal injury case?
Wow, great question. It's probably the most important part of our job when we present it to either the insurance company or a defense lawyer or ultimately a judge or jury. It depends obviously on the specifics of the case, and it just depends on how badly our clients were hurt. I mean, I always tell people at the end that the folks that get the bigger settlement checks or bigger jury verdicts are the ones that are hurt the most. And those are the people that would rather not get the big checks at the end because they'd rather not be hurt. So that's the number one factor. The worse the injury, the longer the injury goes on, whether it's something that will go on forever or something that gets fixed. Is going to really determine what that number is. And then the other part of the valuation is how much insurance is available. Let's be honest. I mean, you can't, the saying is you can't get blood from a turnip. And that's the reality in our world is that you're really only going to be able to recover up to the amount of the available insurance other than some very few specific situations. So you kind of put the injury, you put how the accident happened or the incident happened, combine how much insurance is available, come up with what the proper amount might be.
Thank you so much for explaining it so thoroughly. How do you define damages in the context of personal injury cases, and what types of damages are typically considered?
So first is the injury, right? And then how much medical bills are incurred. I kind of reject the idea that medical bills are somehow a determining factor to how much a case value is. You'll hear a lot of the insurance industry say there's some sort of a formula, some sort of a multiplier, whether it's 2 times the medical bills, 3 times medical bills, whatever that might be. I just never thought that made much sense. I've had cases where my clients were not really that badly hurt, but somehow their medical bills were, $100,000.
Mm.
And I've had cases where my clients were really, really hurt and their medical bills were less than $10,000. It's just how it happens sometimes. So I never really bought into this concept that the medical bills were somehow some big driver of value. I think that each case has to be looked at individually what kind of client is it? What kind of plaintiff is it? And then what are really the significant impacts of the injury? Is it long term? Is it something that's healed? Does it affect him or her at home? Affect their hobbies? Affect them at work? All that gets put together and what I call like of a Brunswick stew of damages to come up with how we present it to whoever it is the other side, evaluating what that number is.
Absolutely. And so each case is very unique and different. There's no alike case. That's what I try to explain to my clients on the other side as well.
And that's what we try to explain to the insurance industry is that you have to
Mhm.
look at each one of these cases individually and not just say, $25,000 in medical bills, this type of treatment means this type of it. It just doesn't work that way, in my
Mhm.
opinion.
100%. Can you explain, Josh, the difference between economic and non-economic damages in injury cases? How are they calculated?
So the economic damages are pretty easy to calculate, quite frankly. It's what we were just talking about, which is whatever the medical bills are. So if you have a client that, gets in a bad wreck and breaks their leg and they spend, a week in the hospital, you're looking at $100,000 plus medical bill. That's an economic damage. They then have surgery, for the orthopedic practice, and they go forward with recovery and physical therapy. Another $100,000 in medical bills. That's more economic damages. That
Mhm.
really should be the easiest thing for a jury to ultimately compute. If the lawyer decides to present those medical bills to the jury, that would be the economic damages. Anytime missed from work, lost wages, that would be it as well. The
Mhm.
non-economic damages are the harder part, right? That's the pain and suffering. That's the disruption of life. That's the disfigurement of a body part, long-term, care, whatever it might be. And that's a whole lot harder, right? I mean, that's I always say there's no Staples easy button to just hit and it spits out what that should be. Like I said, I reject some notion that it's a multiplier of medical bills. And so you have to just kind of get a feel from past cases, from past experience, from past jury verdicts, from past settlements, from past bench verdicts from judges, from past mediation results. Kind of like buying a house when you're looking at comps. I've been doing this for 20 plus years on both sides of the cases. So it's pretty rare at this point that I see a set of facts or an injury I've never encountered before. So a lot of it is drawing on those past experiences to say, well, what were the non-economic damages there under similar circumstances? And then use that as kind of the goalpost to shoot for.
Mhm. And how do courts typically assess non-economic damages such as pain and suffering?
So a lot of that falls on how good of a job the lawyer does, quite frankly, because that's the jury's job. In the cases that we handle, a judge is not going to be the one who decides what that number is. It's going to be, as they say, a jury of 12 of your peers. And so who knows, right? I mean, it's each jury is different. They come up with their ways of coming up with that number differently. What I always tell people is that I want the jury to view me as very credible, very believable, very honest. And so if I can accomplish that at the end of the trial, when I give the recommendation to the jury, this is the right amount of non-economic damages. Hopefully, I've built that trust with them that they're like, you know what? We don't know how to do this. We've never done this before, but we believe Josh. He's been honest the whole time. That makes sense to us, so we're going to listen to his recommendations. Now,
But
they don't always do. They can do whatever they want, but that's the way we view it. Is that we want to come up with a way that makes sense. There's lots of different methods, and we can go over them if you want, but there's lots of different methods to do it, and then have the credibility with the jury to have them be on your side.
that's beautiful. How do the specifics of an injury, such as severity, permanence, and impact on daily life, affect the case's evaluation?
So if there's any amount of permanency, any amount of continuing treatment, that is a huge factor because we tell our clients that they get one shot at a settlement, right? Um, this is their only chance to get compensation for whatever the wrong was that left them in this position. So we look very hard at what sort of future problems they might be facing. And while you can't predict everything, you can get some records or some statements from physicians about what long-term consequences could be. You can hire life care planners that put together very nice, easily read projections about what future costs could look like. And then, like everything else, you present to the insurance company or the defense attorney or the jury or the judge and say, hey, look, this is what the medical evidence, medical testimony will be about future problems. And, our clients are entitled to recovery for all of that.
What about liability? What role does liability play in the evaluation process?
So there's obviously that's the first step you have to get through, right? If your client is liable or caused the wreck and the other person did not, then the damages don't really much matter, right?
Hmm.
I mean, unless somebody is proven at fault for what happened, then I could be the best damages lawyer on earth and it ain't gonna matter a hill of beans. So the first thing we always have to conquer is proving that the person who we're suing or making the claim against is indeed liable, is indeed legally at fault. In car wreck cases, that can be pretty easy, right? I mean, you
Hmm.
have a police report, you have a police officer and an investigative team that came out and did an investigation, came up with findings, and issue citations. That's pretty easy. At that point, you know that that person's liable. You've got step one done, and you can move forward with your damages. Some of all cases, they're a lot harder. You've got to prove liability and negligence on behalf of the restaurant or the retail place. They knew the hazard was there, did nothing about it, whatever it might be. If you can't prove that, damages don't matter. What I have found is that the cases where the liability is more clear, the damages are easier for the other side to kind of digest. That's pretty simple, right? That makes sense.
Hmm.
In cases where the liability is more of a fight and it could go 50-50, then the other side takes harder positions on the damages.
Hmm.
Again, not hard to understand. I will also say this, though, in cases where damages are extremely high, a death, some sort of catastrophic long-term injuries, even where there's questionable liability, where it could go either way, there's still great value from a settlement perspective from the decision makers because they don't want to take the risk at trial of being wrong on liability and they lose all the damages.
Absolutely. How does the strength of evidence influence potential settlement amounts?
I mean, I think the stronger your evidence is, the better chance you have at getting a good, strong settlement. I mean, we look at each element of, the diagnosis, of the treatment, of the surgery, of the amount of medical bills being appropriate. We want to make sure each one of those steps are indeed strong so that there's nothing that the other side can question us on. And, about being honest and credible. If we feel like every part of the damages case we present in an honest way, that gives us that much better of an opportunity at the end when we make the quote ask for the final number that the jury will agree with us. So if
Hmm.
there's parts of the case that aren't strong, we look at it, how can we make it stronger? And if we can't, we have to just understand that, accept it, explain to our client that, look, the number that you're looking to potentially get can be a little less because this particular factor isn't quite as strong as we would want it to be. It happens. It's part of just being honest and realistic about what the cases are.
Hmm. Hmm. And let's talk for a minute about expert witnesses. How important is expert testimony in establishing the value of an injury case? What types of experts are commonly involved in your cases?
So in my medical cases, because they always involve some sort of a surgery or some sort of a procedure, our expert in that case is just the doctor that performed the procedure, performed the surgery. And it's pretty straightforward. It's as much as, you know, this patient came to me for these reasons. It's my opinion that why they came to me was caused by the car wreck or the fall. My opinion that, the only treatment for this injury was this surgery. My opinion that this surgery was medically needed because of the accident, whatever, however the word is, and that becomes your expert. I mentioned a life care planner in cases where there's going to be a potential for long-term treatment down the road. That's a great type of an expert to talk about, the costs associated with all the procedures that the patient might need. Some cases require economists. If there's a lost wage component, if there's an inability to carry out some household services, any sort of monetary loss related to the wreck, we'll hire an economist to just kind of simply explain, hey, look, this is the dollar and cents amount that are going to be lost because of what happened. In the premises cases and the daycare cases, sometimes we have to hire experts to talk about like a code violation, something wasn't built to code, or if there was something that was done improperly at the facility that they should have fixed. There's premises experts. So we look at that too. Um, Not every case has to have an expert, but the ones that do, it's important to find a good one and not one that is seen in every case and every day in every court, because then they become, what we call hired guns and they
Mm-hmm.
lose again that word credibility. So if we do hire an expert, we want to make sure we're not using the same one time and time again. We want to make sure we use one that testifies both on the plaintiff side and the defense side. That gives them credibility that they call balls and strikes. They're not just hired by one side or the other. We want to hire one that geographically makes sense, right? I mean, here in the South,
Hmm.
bringing in somebody from the Northeast might not be the best decision if there's somebody right here in our backyard. So a lot goes into choosing the right one and making sure it fits within the case.
That totally makes sense. Do you use any particular strategies to select and prepare experts for trial?
Well, I think it goes back to what I just said. Maybe I got ahead of myself a little bit, but the strategy I use is just not using somebody that the other side's like, oh, great, here we go again with this particular person. Making sure it's not someone who's a professional testifier. Jurors see right through that. The questions are always asked about how much the expert gets paid, and we want to make sure that's a reasonable number and it's not something that shocks the jury. The other thing is, in these injury cases, if I have a medical quote expert that was the actual treating doctor, why wouldn't I just use that person, right? I
Mhm.
never understood the concept of bringing in some outside doctor to talk about what happened when the treating physician is the one that really knows the most. So,
Exactly.
so in those cases, my job gets pretty easy when I don't have to really find the expert because the expert is already right in front of me.
Absolutely. Based on your experience, Josh, how do attorneys determine an initial demand when negotiating a settlement for a personal injury case?
A lot of reflection, a lot of reflection. Again, no easy button there. Um, I look at the amount of insurance limits available, and if I feel that the value of the case is at that amount or over, or maybe just slightly below, that's what the demand amount is. It's for the full amount of insurance available, whether it's $100,000 car policy or $1 million policy for a corporation. I don't just demand the limits just because I can. I always want to make sure that the case justifies that kind of a demand. The harder decision is when the case value doesn't reach the policy limits, and that happens a lot.
Mhm.
Um, at that point, you kind of have to come up with what is your number that you think is fair and then work backwards, right? So if I think a case is worth $500,000, I don't want to demand $600,000. That doesn't give me enough room to negotiate. I don't want to demand $5 million because that might show the other side that I'm not being reasonable and I'm pie in the sky and I'm not really looking to resolve the case. So you got to find that sweet spot where it gives you enough room to negotiate but also invites the other side to know that, hey, Josh is reasonable. We know this number's high, but it's not so high that it doesn't give us any, thought or chance that the case can ultimately get resolved.
Mm. And since you've been on both sides, the defense and plaintiffs, what common tactics do insurance companies use during negotiations? And how can plaintiffs counter these strategies?
I think the number one strategy that insurance companies use is kind of daring the plaintiff's attorney to actually file a lawsuit and litigate it.
Mm.
There's so many lawyers out there that, for whatever reason, just won't take that step. I've never quite understood why. Might be the model of their firm, might be because they don't really know or have the confidence. I don't know. But the insurance company's banking on, hey, look, if we offer you kind of close to what is a reasonable amount, we think that the attorney is going to take the easy way out, accept that, lower amount of money, close the case, take his or her fees, get the client paid, and then just move on to the next one. And that happens a lot. And if I was the insurance company, I guess I understand why that strategy is employed. What we have found is that when that strategy is used against us, we just very politely and very kindly tell the insurance adjuster that we appreciate it. This is not going to work. We're not close to a resolution. We're going to put in a lawsuit. We're going to go through the process, take the depositions, exchange the discovery, and then once that happens, they seem to open their eyes and the defense attorney gets involved and they say, what are we doing? Josh's demand is somewhat reasonable. We need to take another look at resolution. And there's different tools and tricks you can use along the way. But that's the number one thing for me is just not being afraid to push it to litigation and then not being afraid to push it to trial, right? That's the
Mhm.
second kind of hurdle is that the insurance companies don't take plaintiffs' lawyers seriously that they don't think have the ability to actually try the case and work it up so that it'd be successful at trial. Once you start doing that and they realize that it's not going to go well for them at trial, that tactic of kind of, you know, not treating your client with a fair settlement offer goes away.
Mhm. Do past case outcomes and precedents influence the valuation of current injury cases? How so?
It kind of goes back to the analogy I used about purchasing a house and using comps when you see what is a house worth. I think it's twofold. It's number one, jury verdicts, mediation settlements, other settlements within a particular company, using those as kind of the parameters to work with and presenting those to the insurance company, doing, pulling up, this case in 2021 were these facts and it settled for this, whatever it might be. The other one is having the firm having a track record of results that they can fall back on, right? I mean, I can confidently, tell an insurance adjuster that, I've had this kind of case, we tried this kind of case, this was the result we got. We've handled these sorts of matters. Look on our website, you can see the results we have because they're sizing up the plaintiff's lawyers too. So I look at it both ways. What kind of case, what have similar cases resolved for? What have similar cases gotten at trial verdicts? And the individual lawyer, what kind of results does that person have?
Mm. So, are there any particular cases, of your own or any of your friend attorneys in Georgia or nationwide that you know of that have significantly impacted how injury cases are valued today in
So
today's market?
the plaintiff's bar does a pretty good job of sharing results amongst ourselves, in terms of, hey, this trial just happened. These are the facts. This is the judge. This was the court. This was the verdict. So I try to stay on top of that. I'll give you an example. I have a case going on right now. Someone slipped and fell at a place of business, broke their leg. We've proven liability. We've proven that the facility was at fault. So now the question is just how much is this injury worth? And so what I do is every time I hear of a peer that is recently getting a verdict on a similar type of case, I just send it to the defense attorney. I send it to the adjuster and I say, hey, look, in 2 weeks ago in Fulton County in front of Judge Richardson against this company, this kind of injury, this kind of plaintiff, these sorts of medical bills resulted in this kind of a verdict. Just to let them know that that's what's going on out there, right? I mean, there's no better example they can use or talk to their boss about than a current verdict in a very similar sets of facts. So I'm always, looking for that. I'm always, copying and pasting and saving in a folder, cases that are similar to the kinds I handle. So I can very quickly kind of say, hey, look, this is what jurors are doing in this county or this area on this particular type of case.
Mhm. Let's talk about the emotional and psychological factors in personal injury cases for a minute. In what ways can the emotional impact of an injury on the plaintiff affect the valuation of the case?
It'd be hard for an insurance company to really understand that and put their arms around it and grasp it because they're so trained to look at, well, it was a back injury, this treatment was had, they did therapy, they got some injections, they got better, they have $25,000 in medical bills. It should be this kind of a case. And they can tend to ignore the psychological and the emotional parts of this. A lot of my clients are afraid to drive after wrecks. A lot of my clients are afraid to get in cars. A lot of my clients aren't able to go to work for a while, and that causes mental stress on them. So the only way that I know how to do it is just to make sure I educate the insurance company about it. I can't control what their ultimate response is going to be, but I can control the amount of information I provide to them. So, that's why my demand letters are probably a little bit longer than others because I do spend a section talking
Mhm.
about the psychological, emotional things like that, to make sure that they know that's part of the case and that if and when this case, our depositions are taken or going to trial, this is what my client's going to say. And this is going to be something that is impactful on the jury, we think. And then if they reject it, that's their prerogative. We go forward. And at depositions, our client says these things. And then at that point, again, they can accept it or they don't. I can't force them to. But all along, I think my job is to make sure that those key parts of the case are explained well by my clients, and if nothing else, are at least passed along to the decision makers because they do play a big role and they are real and they are part of the human story that is part of all these cases.
Mm. Sorry about the background noise. New Orleans is loud this morning. So do you have any particular methods or ways that you use in your cases to assess and quantify psychological damages in personal injury cases?
I think it goes back to just drawing on past experiences. This is what values are for similar types of injuries. Again, recognize the amount of insurance available and seeing how that plays into it. I wish there was some formula. Actually, I don't wish there was some formula because that would make it, not really unique to each person. I guess I do wish there was some way of demonstrating it other than just what I said, which is just educate them, let them understand that they can't just look at the medical bills and do some sort of multiplier, that there are other aspects of this case that aren't just black and white.
Mhm. Are there any regional differences that you know of in how injury cases are valued? How can these variations affect a case's outcome? So let's
Big
say,
time.
I don't know if it's by county, let's say if, we live in Georgia, Fulton County versus Gwinnett versus Cobb, for instance.
Yeah, yeah, great question. So I'll even expand out a little bit more. You probably have listeners nationwide and worldwide. The value of a case and how you look at it differs from jurisdiction to jurisdiction. The way cases in Georgia are viewed are different than in North Carolina, different than in Alabama, different than in Florida. So that's the first thing you have to understand. Georgia, we have some ways to present cases that can be favorable to our clients, and lawyers need to understand that and take advantage of that. You then have to look from a county by county standpoint. And as I have been doing this, what I've learned is that, I think that the client, him or herself, is the number one most important part of the evaluation. The injury, of course, is what it is. That becomes important. But the unknown and kind of unheralded part of the evaluation is the venue, is what county will the case be tried in. A case that is tried in DeKalb County or Clayton County has considerable different value than a case in Cherokee. Venues and counties where they are more urban in the city, have more of a liberal leaning, they just award higher numbers. When you get out into more of the rural counties, they just don't. And so insurance companies understand that, attorneys understand that, and that becomes part of every discussion. It's like, well, this case is going to be heard in DeKalb County, which makes it a different analysis if it's heard in Barrow County.
Mhm.
So understanding your venue, figuring out ways to get into better venues, right? Like you can't form shop, you can't get someplace where you're not supposed to be, but lots of our cases, there's two or three potential choices of venue where to file it. And the smart plaintiff's lawyer knows that and can choose of the three, what would be the most beneficial venue for their client. And whether you try the case or not, it's going to reflect itself in a higher, settlement number.
And you Josh, kind of, almost answered this question, but can you explain, please, how do state laws influence the calculation of damages in personal injury cases?
Yeah, so the legislator puts laws in place that then control how cases can get handled. Like for example, medical bills. Some states you can't present the full medical bill amount to a jury. You can only present how much has been paid, whether by health insurance or otherwise. Some states, if a plaintiff is 1% at fault for what happened, they cannot recover at all. Some states, like Georgia, puts a percentage of fault on a plaintiff, and that gets applied to what the final verdict is, as long as it's less than 50%. So there's rules of evidence that go with how you can present damages to the jury. So all that is to be said that, not understanding the specific rules or laws of your jurisdiction and how this case will ultimately be presented to a jury can be a big, big problem. I mean, I talk to adjusters every day and they handle cases all across the country. That's just the nature of their business. I wouldn't expect these adjusters to have memorized the specific laws of every state. I wouldn't be able to do that if I were them. I think it's too big of an ask. And so what I do is I make sure in my letters and in my conversations with them, I say, this is in Georgia, how this is going to play out. This is the law in Georgia about medical bills. This is the law in Georgia on contributory negligence. And they appreciate that, right? I mean, they want to be told or led to understand what the specific laws are. And so that's part of what we have to do.
That's amazing. thinking about the future, how is technology changing the way injury cases are evaluated and valued?
I might be the wrong person to ask about that. I know there's lots of tools out there. There's lots of AI tools that will um, take information and they will to put in certain phrases and words and calculations that speak to the insurance industry that can kind of work in tandem with what we understand the insurance industry's technology is looking for. I haven't gone down that road yet. I know I have some peers that do, and they love it and they swear by it, and that's great for them. I think that it's something that we can't help that's happening. I mean, Chat GPT is everywhere. I know people are using Chat GPT to help them with some of their settlement demands and briefs in court. I would just warn people to make sure that you double check everything that comes out of Chat GPT. There's been too many examples of lawyers that have just taken that what it was, sent it to the court, and then got really embarrassed when a judge pointed out that the case they cited to prove their point doesn't even exist. So I think there's a place for this stuff, this AI and this new technology. I haven't found the perfect sweet spot yet, but doesn't mean I'm not going to. I would just say people can look into it, make their own decisions, but just be careful with having a computer do all the work for you.
I agree. What advice would you, Josh, give to clients seeking to understand the valuation process of their injury case?
I tell the clients on day one that any lawyer that tries to tell them what the value of their case is lying to them. And if a lawyer is promising this is $1 million case on day one, that's not a lawyer that you want to work with because it continues to grow and flow and it changes and it's very organic in terms of how you reach the proper valuation amount. I mean, I had a client here recently that her case was probably worth $25,000 when we first started talking to one another, but then she just didn't get better. And she ultimately ended up having to have a shoulder surgery, and it ultimately resolved for the maximum insurance of $250,000. So a 10-time kind of swing, not because I did anything amazing, just because her case changed. And so you just have to be very open with your clients. You've got to be in constant communications and dialogue and explain to them, this is the way we go about coming up with an evaluation, with a number. This is what we're going to present to the insurance company. This is how much insurance is available. And then whatever it is that you get back, you got to be prepared to have a conversation with the client about whether that's fair, whether that's reasonable, what the options are. I've never had a client get, quote, mad at me about, a settlement offer or a settlement because they weren't surprised, right? Like they always knew like this is kind of the range we're going for. And they always also know that if they don't like the number or if I think it's not fair, that they trust me to then move forward with filing a lawsuit or taking it to trial.
Mm-hmm.
The other part of that, though, that I think sometimes people miss is that if you gain credibility with your clients by being in contact with them, staying in touch with them, in the process to them, if that offer comes, it's pretty fair and reasonable, and you tell them that, they're going to listen to you and they're going to accept that settlement demand that they should have. If you're not open with them, if you're not talking to them, they have no reason to think that you're on their side. And if you recommend they accept something, they're like, well, we don't really care what Josh has to say. We think we deserve more because my uncle got more. I saw on TV that, Morgan got $1 million. I saw this billboard. So we're constantly fighting what the outside noise is telling people is right, or what it should be with what actually is reasonable and what is right.
That was so great. I hope this episode about valuation of personal injury cases was informative and educational. And as promised, here's a fun pop question for you, my dear. You ready?
Sure.
And this will be quick. So you have to answer super quick. No thinking, okay? Coffee or tea?
I drink coffee every morning. I drink about 3/4 of a cup. That's all I can take down. I always enjoy tea, but I don't have much exposure to tea. If anybody has any of your listeners has recommendations of good teas to have, I'm open.
Listen up to that. Courtroom drama or legal documentary?
Oh gosh. We watch Suits. Me and my wife and daughter enjoy Suits. I don't know which one that falls under, but I usually get kind of turned off by legal shows, but Suits is great. We've gone back and caught up, so that'd be my answer.
Nice. I need to finish that up. I really enjoyed it too. Judge Judy or Atticus Finch?
Well, those are two different sides of the spectrum. I mean, I guess the right answer is Atticus Finch, right? A lot of people say that reading To Kill a Mockingbird and being inspired by him is what led people to the practice of law. I actually recently read that book because my daughter or my son, I can't remember which one, they had to read it. So I revisited it. Nothing wrong with Atticus Finch, great guy. I will tell you though, Judge Judy, um, she's worth like $500 million or something. I mean, literally, she has somehow maintained ownership and production of her show and has just made way more money than she ever would have made as a practicing lawyer. So if I was following money, I would say Judge Judy. If I'm following my heart, I would say Atticus Finch.
I love it. That was such an amazing time spent with you today, Josh. If anyone is looking for your professional help and J. Stein Law Firm in Atlanta, Georgia, how can they reach you?
So my website is www.jsteinlawfirm.com, Jstein lawfirm.com. Phone number 404-418-6379. On the social media, Instagram, J Stein Law Firm, Facebook, J Stein Law Firm, LinkedIn, Joshua Stein, TikTok page. So find me wherever.
I love it. That was again Joshua Stein with J. Stein Law Firm based in Atlanta, Georgia. I want to thank you all for listening and watching our story today. For more tips and tricks on legal funding and personal injury law and medicine related topics, follow me, download, like, and subscribe for It's Time for More Injury Funding podcast on several podcast platforms worldwide, and follow More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google Business Profile, and my website at moreinjuryfunding.com. I can't wait to see you, my dear listeners and viewers, at my next upcoming episode. Tune in soon for our next guest. Until then, be well. Thank you.
Thank you.